For judgment. I have written about 101 pages of the judgment. It is not my intention to read the totality of the judgment because I do not want to detain the parties for more than one day if needs be. I will just deal with the introduction of the judgment, and then I will deal with the context, and then I will skip my summary of the 1970 inquest evidence that was led. I will also skip my summary of the evidence that was led in the reopened inquest, and I will join later the judgment in dealing with the law that I will read into the record, as well as my analysis, my findings and orders. So that is how the judgment will be structured. Now, ordinarily, one doesn't give a judgment a title, it just remains a judgment. But I couldn't help myself but to title this judgment "The Last Days in the Life of the Imam and Anti-Apartheid Guerrilla, 28 May to 27 September 1969. That is the title. Now, this is the judgment on the reopened inquest into the death in detention of a political detainee during apartheid South Africa in September 1969. From the 18th of February 1970, a formal inquest was held before Additional Magistrate J.S.P. Kun, hereinafter referred to as the magistrate, into the circumstances attending to the death of Abdullah Haron, hereinafter referred to as the Imam. The inquest was held in Cape Town in the District of the Cape. On the 10th of March 1970, the magistrate made 4 findings in terms of Section 16 of the Inquest Act 1959, that is Act number 58 of 1969. And the findings were the following. A, on the identity of the accused, Abdullah Haron, also known as Abdullah Haron, a Malay male about 45 years of age, a shopkeeper. On the date of death, 27th September 1969. On the cause or likely cause of death, myocardial ischemia, a likely contributing cause being a disturbance of the blood clotting mechanism and blood circulating due in part to trauma superimposed on a severe narrowing of a coronary artery. D, on whether the death was brought about by any act or omission involving or amounting to an offense on the part of any person. A substantial part of the said trauma was caused by an accidental fall down a flight of stone stairs. On the available evidence, I am unable to determine how the balance of thereof was caused. That was the findings of the magistrate. For the past 54 years, the Imam's family, friends and comrades in the apartheid struggle never accepted the findings of the magistrates as regards C and D. According to them, the Imam was one of those, and I quote, from whom before and after their deaths, justice was not only blind, but also deaf and dumb to what was being done to those who suffered under and had the courage to oppose a racist regime turned brutal tyrant. Close quote. And here I'm quoting from No One to Blame in Pursuit of Justice in South Africa by Advocate George Bizos SC, David Philip Publishers, Cape Town, Maibuye Books, University of the Western Cape, Bellville. In its introduction, that book quotes 2 outstanding thinkers of their time in the opening stanza. Milan Kundera is quoted as having said, and I quote, "The struggle of men against power is the struggle of memory against forgetting, close quote. President Nelson Mandela, when he signed the Promotion of National Unity and Reconciliation Act on 19 July 1995 said, and I quote, "We can now deal with our past, establish the truth which has so long been denied us, and lay the basis for genuine reconciliation. Only the truth can put the past to rest," close quote. Simply put, the questions that the family, friends, and comrades of the Imam had in respect of the disputed findings can be reduced to the following. Was the Imam killed? And if so, by who and how? The context. In 1960, popular opposition to apartheid became more visible. The Pan-Africanist Congress, hereinafter referred to as the PAC, called protest marches against past laws, including in Langa and Nyanga in Cape Town. In other protests called by the PAC in Sharpeville, 69 protesters were gunned down by the police. The government declared a state of emergency. Some 18,000 people were detained. The Unlawful Organizations Act was passed, banning, amongst others, the PAC and the African National Congress, hereinafter referred to as the ANC. The organizations went underground. The Imam worked for the organizations struggling for the liberation of the majority of South Africans. He, amongst others, served on a fundraising committee which provided money for the alleged defense of victims of the security police, which were inherently opponents of colonialism and apartheid. He was appointed the Imam at the Al Jamia Mosque, Stegman Road, Claremont, in 1955. He was a respected Muslim religious leader, a recognized authority on Islamic theology and law, and a spiritual guide. He gave sermons and public lectures in which he was critical of apartheid South Africa's racial laws. Amongst others, on 7 May 1961, at the Cape Town Drill Hall, he described the Group Areas Act as an inhuman, barbaric, and un-Islamic law, and as a complete negation on the fundamental principles of Islam. He told the audience that the laws were designed to cripple his people educationally, politically, and economically, and that the people could not accept the type of enslavement. He worked with African anti-apartheid activists in Langa, Nyanga, and Guguletu. He urged Muslims to support Africans in their fight against apartheid. He had contact with anti-apartheid activists like Alex Laguma, Albisex, Professor Hoffenberg, Robert Sobukwe, and Bani Desai, hereinafter referred to as Desai. It was through Desai that he supported underground activities of the PAC and the ANC. He discovered that police had informers in his congregation. This is how he became known to the security branch of the police. By 1965, he was identified by the security branch as a security risk. He traveled to Mecca in 1966 and, together with Ibrahim, Bani Desai's brother, lobbied the Islamic World Council to intercede with their governments against apartheid. He engaged with PAC members in Cairo and addressed a conference attended by members of both the PAC and the ANC. He became involved in recruiting young men to undertake short courses on guerrilla training outside South Africa, under the auspices of leaving the country to go on a Hajj, a religious pilgrimage to Mecca. He met Canon John Collins, who, through the Christian Action, established a fund from which funds were channeled to the Imam to assist those left poor and destitute through political activities. The security branch started to pay intermittent visits to the Imam's home. They also raided the mosque and scrutinized his bank accounts. Desai warned the Imam to leave South Africa. The Imam did not leave immediately. The Imam was arrested by the security branch on 28 May 1969, the day of Milad-un-Nabi, the celebration of the birth of Prophet Muhammad. The Imam was detained for being a political opponent of the apartheid regime. The arrest of the Imam on this date signified two things. First, that he was sold out by a Muslim. Secondly, that the SB sought to undermine the Imam's stature and his faith. To sell out, you betray your own benefits. You corrupt your own goodness with a character trait that is temporary, weak, and selfish for a quick comfort. You abandon your own principles for reasons of expediency. You trick and deceive your own destiny and legacy. Well aware of this betrayal of the Imam, Muslims, including outside the borders of the Republic, are eagerly awaiting this judgment in the hope that it will set the record straight, not only about the death of the Imam, but about the truth of their faith. During a lifetime of oppression, a religious leader, following his faith, stood up and spoke out against injustice and oppression. Not to speak out would have been a refutation of his beliefs, his morals, his principles, and his reason for being. For doing that, he was detained by the security branch. On the day that he was buried, many Muslims remember that the earth shook in what in the Cape became known as the Tulbagh tremor. This was a reminder to Muslims that even the natural order had been unbalanced and the unnatural demise of the Imam. A verdict was handed down to his family and the community that no wrong was done and no criminal liability could be attributed. The Muslim community did not forget that the Minister of the Police at the time said, and I quote, "It was not in the interest of the public to know why he was detained," close quote. From an Islamic perspective, a great wrong was done. A wife was widowed, children deprived of their father, a family torn apart, a community wounded, a society aggrieved. The apartheid state hid the details of what happened to the Imam. The purpose of this reopened inquest must be to go back and uncover that which had been hidden and to assert that in a constitutional democracy, it is very much in the public interest to know the truth. I am mindful of the wound that a family, a religious community, the greater society of South Africa, and others around the world have carried for over 5 decades. Oppression is described in the Quran as a dark covering cloud. The dictates of truth require that we dispel the cloud of oppression that has hovered over this case and to bring the light, because with light we know the truth that can begin to be revealed. I read that there is a hadith which reads, and I quote, "And say, truth has now arrived, and falsehood perished. For falsehood is by its nature bound to perish." And this is in the Holy Quran, Bani Israel 1781. The context of this hadith is not for me to comment on. But as a principle, it is noted that when a society starts to live truthfully, the dark clouds of oppression will dissipate. Truth has the quality of rolling back the darkness, little by little. We cannot say truth has now arrived, but by dismantling falsehoods, we can begin to arrive at the truth. And as I stated in my opening remarks at the start of this inquest, begin to restore the balance. I am aware that in particular many Muslims are eagerly awaiting this judgment because it would shed light where there had been darkness and set the record straight, including in their faith. If we are serious about social justice, we cannot twist and turn away from and deviate from the truth. What is known to be true must be set out. The question that will remain for the families, individuals, and for society, especially in South Africa, is when we have that truth or arrive nearer to that truth, what do we do with it? Truth is powerful and can empower individuals, families, and societies. I am, however, humbled to know that from an Islamic perspective, revenge is only secondary. A much better path is to continue to counter evil with good. We know that the Imam's life taught courtesy, kindness, courage, endurance, values, and principles. The Imam's life was one well lived. It was a display of the virtues and victories of his Islamic faith. This manifested in a humble, courteous, and kind man with a trait of excellence in his social, moral, intellectual, and political outlook. His disposition was to choose to do what is right, even when it was difficult and resulted in excruciating pain to his physical body and led to immeasurable struggles to his family, friends, and comrades. Extrajudicial killings and criminality were the order of the day during the apartheid struggle, especially within the security branch of the South African police. Legislation, including the Terrorism Act, especially the provisions which allow detention without charge and the trial at the instance of the security branch without any judicial oversight, became a tool in the hands of the security branch to torture and even kill detainees with no consequence management for perpetrators. At the Truth and Reconciliation Commission, a former commander of the security branch, Johan Velde van der Merwe, put it in these words, and I quote, "All the powers were to avoid the ANC SACP achieve their revolutionary aims, and often with the approval of the previous government, we had to move outside the boundaries of the law. That inevitably led to the fact that the capabilities of the SAP, especially the security forces, included illegal acts," close quote. And this is found in the Truth and Reconciliation Commission Report, Volume 5, Chapter 6, Findings and Conclusions at paragraph 77. I have indicated that it is not my intention to read out my summaries of the 1970 inquest, as well as the summaries of the reopened inquests. And I will move straight from page 6 to page 70 of my judgment, where I start dealing with the law. Section 17A of the Inquest Act reads as follows, and I quote, "Reopening of inquest. 1. The Minister may, on the recommendation of the Attorney General, consent at any time after the termination of an inquest, and if he deems it necessary in the interest of justice, request the Judge President of a provincial division of the Supreme Court to designate any judge of the Supreme Court of South Africa to reopen that inquest, whereupon the judge thus designated shall reopen such inquest." Subsection 2. An inquest referred to in subsection 1 shall, subject to the provisions of this Act, as far as possible, be continued and disposed of by the judge so designated on the existing record of the proceedings, and the provisions of section 17.2 shall, insofar as they are not contrary to the provisions of that section, apply mutatis mutandis to such inquest. 3. A judge holding an inquest that has been reopened in terms of this section may cause any person who has already given evidence at the inquest to be subpoenaed to give further evidence, shall record any findings that differs from a finding referred to in section 16.2, as well as in respect of which it differs, and shall cause the record of the proceedings to be submitted to the Attorney General consent. Section 16.2 of the IA reads as follows, and when I refer to the IA, I'm referring to the Inquest Act. 16. Finding. The judicial officer holding an inquest shall record a finding upon the inquest: A, as to the identity of the deceased person; B, as to the cause or likely cause of death; C, as to the cause of the date of death; D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person, close quote. Section 17 of the IA provides, and I quote, "Submission of record to Attorney General. 1. Upon the determination of an inquest, the judicial officer who held the inquest shall B, if as in terms of section 2D recorded a finding upon the inquest that the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person, or C, cause the record of the proceedings to be submitted to such Attorney General, close quote. And here now I begin my analysis of the evidence. The Imam had the chest pain from the last half of June 1969 and had been taken to Dr. Viviers. The Imam told the doctor that he was injured. The doctor did not ask him how he sustained the injury. Dr. Molefe had issues with the ethical conduct of Dr. Viviers Haron. Doctors ask targeted questions, and their further examination is guided by the answers that the patient gives. The doctor's personal policy is irrelevant. The objective of seeing a doctor is to get medication for pain. A doctor's role is to probe and investigate complaints, to find the cause behind it, and appropriate questions have to be asked. A systematic inquiry is done as to the source and the nature and background of the pain to determine if it is correlated with the incidents that had occurred, if any, so that the appropriate feedback can be prescribed in the form of medical care and medicine to be administered. History taking can be prescribed in the form of medical care and medicine. History taking and exploration of symptoms is a crucial and integral part of examination and eliciting findings and arriving at a conclusion. From a medical point of view, Dr. Viviers was negligent. Dr. Viviers confirmed that the nature of the injury was such that it was possible that the Imam was assaulted. This was the pain on the left rib cage more towards the middle. Dr. Viviers prescribed Analgen S8 tablets as painkillers. Dr. Viviers excluded heart problems as the source of the pain, as there were no such symptoms. The injuries to the ribs, at least those on the left of the rib cage, were sustained before or know about the last half of the month of June 1969. These injuries were the reason the Imam complained to the SB and had to be taken to Dr. Viviers around the last half of the month of June 1969. It is worrisome that Dr. Viviers prescribed other medication to the Imam without seeing the Imam on a different occasion. The medication was given to Heldenais. The evidence of Dr. Viviers demonstrated a troubling relationship between the police and the office of the district surgeon. On the advice of the security branch, the district surgeon could issue prescriptions for a political prisoner or even give out such medication within the district surgeon's own available stock without an examination of that prisoner and without even seeing the prisoner. From the evidence of Dr. Viviers and the alleged conduct of Heldenais, it is clear that the chest pain did not heal and caused Heldenais to seek further issue of the medication for the chest pains. The chest pains did not go away because the Imam complained to the Chief Magistrate about it again on 7 July 1969. When the Imam was moved from Caledon to Maitland, he already suffered from chest pains, which according to Dr. Viviers were possibly caused by an assault. It is the chest pains that made it impossible for the Imam to exercise and instead to walk about the courtyard during exercise time. It is difficult to allow oneself to be guided by the totality of the evidence of Dr. Viviers, who did not keep notes. One of the pointers of the necessary caution is his description of the Imam. The evidence in total makes out the description of the Imam as light, slender, but of normal weight with regard to the ratio between weight and height, which was average. Dr. Viviers saw the Imam twice, but described him as dark, short, and overweight. Clearly, Dr. Viviers gained from his imagination in certain aspects of his evidence. His recollection was not accurate. The Imam had complained of these chest pains, as I said, since the last part of June 1969. The medical attention to him was simply recycled instead of being escalated. The Imam complained to Dr. Gosling about the general discomfort and specifically a chest pain. The police were aware of this complaint since the last part of June. The suggestion by Dr. Gosling that these were general pains and aches on the Imam's joints and muscles attributable to a flu-like illness by 10 July 1969 is rejected. Dr. Gosling himself acknowledged that he did not ask the Imam what the possible cause of the pain was, as he did not deem it important. This conduct of a medical practitioner in not asking the patient necessary questions was negligent. The evidence by Dr. Gosling that the Imam had the general discomfort and general pains for a day or two was simply untruthful. The continued complaint of the Imam about chest pains caused by police or caused the police to take him to a district surgeon towards the end of June when he attended to Dr. Viviers, and on 7 July 1969 after he complained to the chief magistrate when he attended to Dr. Viviers again. The same complaint caused the police to take the Imam to a different district surgeon 3 days later, which is on 10 July 1969, to Dr. Gosling. The pain described by Dr. Viviers on the left side from around 5th to 8th rib and by Dr. Gosling, which were general pains and aches, were in keeping with the chest bruisings. The chest pain affected breathing and free mobilization. Breathing could not be seized and the chest was particularly painful, disturbing and inhibiting normal function. It was not surprising that the chest pain was the Imam's overarching complaint throughout the period of his detention. Speicher interrogated the Imam, writing a statement, according to him, from 2 July. As he interrogated the Imam, he wrote down a statement attributed to the Imam. On Speicher's version, he did not interrogate the Imam on the week of 5 to 7 July. It was after the interrogation by Speicher on 2 to 4 July every day that on the Chief Magistrate's next visit on Monday the 7th, the Imam reported to the Chief Magistrate for the first time the chest pain. The Chief Magistrate told Khienes to call the district surgeon to attend to the Imam. Security branch members had been aware of the Imam's chest pain. The visit of Van Grienen, the acting chief magistrate, to the Imam was between the first chest pain and the last part of June 1969, and the chest pain reported to the CM on 7 July 1969. The Imam did not report the chest pain to the acting chief magistrate Van Grienen on 23 June 1969. Between that date, 23 June 1969, and 7 July 1969, the interrogation of the Imam by Speicher, while also writing down the statement, happened. And immediately after this, its first part of the Imam reported pain to the Chief Magistrate. Speicher, during the interrogation, continued to assault the Imam. It is not for this court to speculate whether the existing injuries were brought to life by being agitated or new injuries were added to the assault. It suffices that they brought such pain to the chest that it was necessary for the Imam to report the pain to the Chief Magistrate. It was as a result of the assault that the Imam experienced general malaise, a painful chest, and that Dr. Gosling discovered localized tenderness over the Imam's lower ribs when he examined the Imam on 10 July 1969. It is unfortunate that Dr. Gosling only provided some routine treatment for influenza-like illness to the Imam at the time. Dr. Shua found a fracture on the costochondral junction of the 7th rib, with no fresh bleeding during the post-mortem. Dr. Molefe explained that costo meant cartilage and chondral meant rib, in explaining that this fracture was at the junction between the cartilage and the rib. This cartilage is the one that connects the rib to the sternum or breastbone, which is in the middle of the chest. Dr. Molefe's literature search established that these kinds of fractures were quite uncommon. They were typically caused by what was described as high energy impact. They were typically painful fractures just like a fracture of the rib. These fractures were unique in that they were easy to miss on normal radiology. They were not visible on normal X-ray chest. A rib fracture could be missed on X-ray, but if a patient pointed exactly at the place where the pain was, then the doctor or radiologist was able to zoom in that area and double check for the fracture. Costochondral fractures were different in that they were not visible because cartilage was not visible on X-ray. They were typically picked up by ultrasound or a CT scan. They were also not well studied, and therefore no one really knows how well they heal, how soon they heal, or if they even heal. Although Dr. Molefe tried to search to understand if the fracture could have been caused in July or September, there was no literature guidance. She concluded that this fracture could have happened at any point, that is, from before mid-June to September 1969. In understanding the Imam's pain, the cartilage is what offered the chest cover of breastbone and rib bones the flexibility in the movement associated with a breath in and out, by allowing the ribs and the breastbone to move inwards and outside. The cartilage is at the small little joints that allow the expansion and collapsing of the rib cage in breathing. No doubt, the Imam had been in immense pain since around June 1969. The Imam was in a worse condition than the police and Dr. Gosling gave the position out to be as at 14 September 1969. Two reasons underpin this conclusion. First, ordinarily, a prisoner or a patient is taken to the consulting rooms of the district surgeon. This is the general default position of consulting any doctor. It is generally under extraordinary conditions that a doctor would waive the operational convenience and personal security provided by the consulting rooms or their home or any other such place to attend to a patient where the patient resides. Moreover, according to Dr. Gosling, there were 4 district surgeons for the District of Cape Town, some of whom were on call over weekends, if required. It was on 24-hour call. This was so that at any time an emergency arose, there was a district surgeon available for the police. Dr. Gosling's own testimony was that he was the doctor on call on the weekend, which included the 14th of September. In other words, Dr. Gosling was called to an emergency which arose at Maitland police cells and attended to the cells on that Sunday, 14 September 1969. The emergency which arose was the medical condition of the Imam. Gosling's own testimony was that the police did not call a district surgeon on 24-hour weekend call for little complaints, but for serious ones, or when the police were not happy and asked the district surgeon for help, the district surgeon would go and see the patient. The medical condition of the Imam was an emergency that called for help of the district surgeon on call on Sunday, 14 July 1969. Secondly, once medication is prescribed, it seems that it is generally from 3 days or so that the response to treatment would and is allowed to show, and that on average, it would take at least 7 days for a doctor to want to see the patient again. The fact that Dr. Gosling went back to see the Imam the next day after prescribing him medication and not allowing the 3 or 7 days means that Dr. Gosling saw the Imam as an active case, which required medical assessment and, if needs be, further medical examination and attention within 24 hours of his first visit that Sunday. between 14 and 15 September 1969. Piles are not a life-threatening condition to warrant such attention from Dr. Gosling. According to Dr. Molefe, a medical practitioner would want a patient suffering from piles to come back for a checkup if they know that there is a bigger problem than just piles. It was perplexing that Dr. Gosling would give more attention to piles than to a chest pain. According to Dr. Molefe, chest pain is a cause for concern, and in the very least, a medical practitioner will make sure that it is not anything serious. The only way was to perform a full, thorough examination to exclude that it is not related to the heart or to the lungs, which are vital organs. If there is a disease of the lungs, eventually it will affect the heart, and one needs the heart as the most important organ to function for the rest of the body. Dr. Gosling's report on the true condition of the Imam when he saw him on 14 and 15 September 1969 was simply a lie. Dr. Gosling's conclusion that the Imam had improved considerably so that further investigation of the Imam's medical condition was not considered necessary is rejected by this court. Dr. Gosling was untruthful to the 1970 inquest on the true medical condition of the Imam as at 14 and 15 September 1969 on both days on which he saw him. It must be remembered that both Dr. Gosling and Dr. Viviers were district surgeons. The two district surgeons, individually when they saw the Imam on separate occasions, failed in their primary responsibilities to properly examine the Imam on the days that they saw him and did not report specific examination or findings of the chest trauma, nor did they offer a specific diagnosis of the Imam's symptoms, including his stomach ailment. The record keeping of what was noted during a medical examination was good practice that was handed down for years as guidelines in the health profession. It was necessary to make a good and complete comprehensive report of the findings, especially of a person who was in custody, and in particular a person who was a political detainee. Not only did the doctors fail to keep a proper record of their medical examination of the Imam, they also failed to communicate truthfully what their medical examinations were and what care the Imam needed. And they did not refer the Imam for any further examination when everything indicated that that was what the Imam needed at the time that they saw him. The period 2 July to 7 July 1969, on Speaker's version, was the period when the police were interrogating the Imam daily to extract a statement from him, which statement was supposed to be to the satisfaction of the security branch. In other words, the Imam had to tell the security branch what the security branch wanted to hear. On the 7th and 10th July, the Imam complained of chest pains and tenderness to the left rib. Together with the period 14 to 19 and 20 to 27 September 1969, these three periods of 7 days each represent the high water mark point, which was the maximum rise of the desperation and reflected the all-time high in respect of the division of time and brutality of the security branch towards the Imam. While the Imam was a medical emergency as at 14 September and was denied the proper medical care, he was removed from the police cells in Maitland from 17 to 19 September 1969. The further interrogation from 17 September, according to the security branch, was about the lies in the affidavit that the Imam had made during his interrogation earlier from 2 July. The security branch refused to tell the 1970 inquest where the Imam was taken during 17 to 19 September and what happened to him. What the 1970 inquest was told was that the Imam was taken out of the Cape Peninsula. He was taken out for investigation by security members, including Speaker. What the evidence showed was that the security branch confronted the Imam about certain aspects. The discrepancies between the affidavit which the Imam had made around 2 July, in contrast to what the SB believed their investigations revealed. The security branch had the affidavit with them as they interrogated the Imam. The very next day, after the Imam was returned from an undisclosed destination, that is on 20 September 1969, the Imam made the first of 5 complaints of ill health made thereafter in that week. It is the complaint which included the headache that caused Geldenhuys to be involved on the 20th. Remember, the Maitland police called Geldenhuys on the 20th. It was the chest pain complaint to Malan on the 20th and the 21st. It was the complaint to Genes which caused him to get tablets from Dr. Viviers on the 22nd. It was the complaint of chest pain to Malan on the 26th and the complaint of stomach pains on the 27th to Berger. The interrogation on the security branch's own version continued even the Imam was bedridden in the week of 20 to 27 September 1969. When Fesser and Malan next saw him on the 20th, the Imam complained of chest pains and looked very sick to Malan, such that Malan reported this to the security branch, in particular Geldenhuys. Yet the security branch denied the Imam medical care which he denied. These 3 7-day periods, that is the 7 days in July and the 2 7-day periods in September, was when the brutality to the Imam reached its highest peak. What is more disturbing is the support and enabling environment provided by 2 medical doctors, Dr. Viviers and Dr. Gosling, who both dismally failed to provide the necessary medical assessment and attention to the Imam that he so desperately needed at the time. The failure is worse because they were 2 of the 4 district surgeons of Cape Town. It is amongst others failures like these which deepen public distrust and loss of confidence, which the medical profession must acknowledge, were clear symptoms of things having gone wrong in a profession that was supposed to be noble and save lives. It was easy for the security branch to get medication from a district surgeon for use in a political prisoner. It should not be surprising that the security branch got medication, doloxine, to sedate the Imam for over a week without taking the Imam to the doctor. If the totality of the evidence is considered, it is not a quantum leap to conclude that a district surgeon, probably Dr. Viviers or Dr. Gosling, gave Geldenhuys the doloxine that was used to sedate the Imam in the week of 20 to 27 September 1969, when such district surgeon did not properly examine the Imam or to ensure that the doloxine was administered under medical supervision and intensive care as was expected. Geldenhuys lied when he suggested that doloxine, which is what I found was given to the Imam, was medication prescribed for his personal use at home. There was an underappreciation of the severity of the pain, an under-documenting, and oftentimes a deliberate non-investigation and non-documenting of the causes of the pain, not only by members of the security branch, but by also medical doctors, in particular Dr. Viviers and Dr. Gosling. This was the manifestation of a partisan attention to the recipient related to the medical care of the Imam. The Imam was a victim of torture by the security branch as a political prisoner who opposed apartheid. This excludes the narrative of Dr. Viviers and Dr. Gosling as being a significant and reliable source of a truthful and straightforward record of the Imam's medical condition. According to Geldenhuys, the Imam told Dr. Viviers where he had pain. Dr. VBS did not have any privacy with his patient. Members of the security branch were present during the medical examination. It was very strange that the Imam would complain of ill health and not ask to be taken to a doctor, but to ask Geldenhuys to give him something. Geldenhuys lied when he said that the Imam asked for medicine from him instead of requesting to be taken to the doctor. To quench a thirst, naturally, one would ask for water and not cool drink and ice cream. It is common knowledge that there is a belief that frozen or cold items could ease pain. Cold drink and ice cream's cold state is generally believed to numb sore areas, and that the cold temperature from both may reduce inflammation by constricting blood flow to the injured area. It seems to me that the provision of cool drink and ice cream by Geldenhuys to the Imam was what Geldenhuys saw as useful tools for the Imam's pain management. We now know that the escalation from cool drink and ice cream by the security branch as management for the Imam went directly to the administration of Doloxine later. Geldenhuys provided the Imam with cool drink and ice cream, in Geldenhuys' view, to make the Imam feel better, with the hope that the cold beverages would have some effect on the Imam's pain level. It was not a benevolent gesture, but a desperate maneuver, especially because the SB did not want the Imam to be seen by the doctor, especially from 20 September 1969. It must be remembered that Dr. Molife's evidence was that a headache, which the Imam also complained of from the 20th of September, was something that needed to be examined carefully, because any disease or injury to the head may deem fatal, and therefore it would require thorough examination to exclude trauma, stroke, and meningitis, which made a headache a serious complaint that warrants a thorough examination. It would be negligent to just issue a pain tablet without knowing the underlying cause of the pain. In my view, the evidence showed that one cannot exclude that the Imam had other types of injuries and pains that were not documented, either deliberately or through negligence. In my view, the visible injuries on the Imam's body discovered at the post-mortem do not actually tell a full story of what the security branch did to the Imam. Dr. Kessie was a district surgeon who was on duty on Saturday, 27 September 1969, and who was called to Maitland and came to certify the Imam dead. This simple truth, together with the evidence of Dr. Gosling that there was a district surgeon on 24-hour call available for the police for any emergency over weekends, is a guarantee that Geldenhuys' version that district surgeons were closed on Saturdays was a deliberate and calculated lie. Geldenhuys responded to the complaint of chest pain on 20 September and went to fetch pills to kill the pain. The security branch seemed to suggest that they paid much attention to piles over a weekend, but did not pay any attention to complaints of chest pains in the morning and severe headache later on the same day over that weekend. It was a headache so severe that Geldenhuys did not think it would be met by an over-the-counter headache tablet, but went home to fetch prescribed painkillers. He lied to Malan that it was a prescription. It was the painkillers which the Imam drank from the 20th until his death. Geldenhuys and other members of the SB did not take the Imam for medical attention. The SB lied about the pain pills given to Imam on the 20th. On Monday, the 22nd September 1969, when according to Geldenhuys, the district surgeon in Belleville was available, the Imam was still not taken to the district surgeon. Geldenhuys was aware that the Imam was in such pain that Maitland police had to inform the commanding officers of the SB. Geldenhuys had experienced the Imam in such pain that, according to him, he had to provide pills prescribed for his own personal use to the Imam. Yet on that Monday or any day thereafter, he did not take the Imam to the doctor, or at least arrange that he be taken to a doctor. Instead, Khaldanais asked for the doctor to prescribe pills for the Imam when the doctor had not medically examined the Imam. The provision of prescribed medication by the district surgeon to Khaldanais, and I've already said that was doloxin, for the use of the Imam without a medical examination is confirmation of the close and seemingly long-term arrangements which evolved between the SB and the state medical personnel, in particular some district surgeons. If the Imam only suffered a headache on Saturday 20 September 1969, it would not make sense for Khaldanais on Monday the 22nd, when he had not seen or heard from the Imam, to still take steps to seek medicine for the Imam. The inescapable conclusion is that Khaldanais was aware that the Imam was in pain that would transcend the Saturday, and that explains why Khaldanais had to attend the pain on Monday and beyond. Khaldanais could have simply called the district surgeon or arranged for the Imam to be taken to hospital. The nature of the medicine given to the Imam, doloxin, not only indicates the severity of the pain, but also the reluctance of the SB to have the Imam receive proper and adequate medical care. The nature of the injuries, the extent of the pain, and the medical response required necessitated the hospitalization of the Imam. I just need to take a short break just to attend to my throat. It'll be 2 minutes. Court agents.
If you need, where the safe phone says you want to make for video line, how many places tour? It's 40. We have musical
All right.
Yes.
Thank you. I have to apologize for that. I think because the courtroom is full, the aircon was adjusted in such a way that it makes the place where I am uncomfortable because the air is directly hitting on me. But let's proceed. I'm at paragraph 145 of the judgment. Rademir gave the names of the pills for the piles by name and could also give the date on which this happened. However, he could not give the dates on which the Imam complained to him of stomach and chest pains. He did not disclose the name of the pills which he found in the office, which the instruction was to give to the Imam upon request. Whilst he could indicate that the pills were prescribed by Dr. Gosling, he did not say from whom the stomach and chest pains were received. The Imam was under sedation through the provision of doloxin at the instance of one of the district surgeons between VVS and Gosling and the security branch, and was held at Maitland from 20 September 1969 under those conditions. Neither the police nor the district surgeon throughout this period sought to cause the proper medical examination to trace the primary explanation of what the underlying cause was of the different types of pain that the Imam complained of. The Imam had been denied proper medical attention to his chest pains since July 1969, stomach pains from 14 September, and severe headaches from 20 September 1969 until his death in police detention on 27 September 1969. It is unknown as to how often these tablets to sedate him were given to him and how many of these tablets were given during the period 20 to 27 September 1969. From 20 September 1969, whilst the Imam suffered these multiple pains, he was never properly, adequately, and truthfully examined by a medical practitioner. I accept the view of Dr. Hellman, who gave evidence in the initial inquest, and find that the injuries found by Dr. Shaw on the Imam caused a great deal of pain, suffering, and immobility. For chest pain, stomach pains, and severe headaches, suppositories for piles could not have been the appropriate and sufficient treatment. From the evidence of Genis, Spijker, Pienaar, and Malan, the SB members saw the Imam many times and also removed him from Maitland without keeping any records of such visits and removals. If it was not for the cross-donation of Cooper SC, the security branch would not have revealed that the Imam was removed from Maitland from 17 to 19 September 1969 and taken to an unknown destination where what happened to him remained a mystery. What the evidence showed is that the Imam returned with serious injuries to Maitland. Since arrival on 11 August, the Imam did not exercise, but sat in the sun. Most of the time, the Imam would be lying or sitting when Rademeier visited the cell. The Imam arrived at Maitland already having a broken rib. This explained why he could not do physical exercises, but elected rather to walk around the courtyard in the early days of his detention. On 26 September, the Imam complained to Malan about a painful chest. Malan informed Genis of the Imam's complaint. The version of Malan stands in direct contradiction to the version of Genis, that on that day the Imam appeared completely normal and healthy and had no complaints, and that on the contrary, the Imam asked Genis and Spijker to come and fetch him on Monday 29 September so that he could tell them something. Genis, Spijker, Geldenhuys, Pienaar, Rademeier, and Berger lied to the 1970 inquest about what happened to the Imam. Of all the police officers who testified at the 1970 inquest, Malan was the only one who did not deliberately fabricate evidence and when confronted, told the inquest the truth, more specifically about the removal of the Imam from the police cells in Maitland by the security branch from 17 to 19 September 1969. Malan was, however, like the rest of the police and security members who testified, true to the texture of that history. That history manifested itself in violence and violations. It deliberately deleted what happened and had a tendency to misremember, if not use and abuse the truth. At its foreground was an agenda, an ability to tell what happened, skewed in their own interests, and an unwillingness to admit things that were done. In its individual and collective thinking, it mastered the art of short-term thinking to look good for that season only. The evidence of Berger at the 1970 inquest was that the scrubbing and cleaning as well as the movement of the Imam to the whites-only cell was a routine procedure done at least twice a week, was not corroborated by anyone, and was clearly a fabrication and stood to be rejected. Between 26 and 27 September 1969, the cell in which the Imam was ordinarily detained was not scrubbed and cleaned innocently. The cell was scrubbed and cleaned after the security branch and the Maitland police realized that the Imam had died. The scrubbing and cleaning of the cell in which the Imam died was a deliberate act calculated to destroy any evidence that could help any honest medical doctor or observant investigator who would attend to the cell as part of the collection of the evidence to help determine the cause of the death of the Imam. It was intended to cover up evidence that could point to the true cause of the death of the Imam. The scrubbing of the cell is not the only pointer to an attempt to cover up. Spijker seemed to suggest that he only saw the corpse of the Imam at the Salt River mortuary at around 8 at night. He said the Imam was naked and lay under two other corpses, that the Imam's body was not covered in a sheet. The naked, uncovered body was not only demeaning to the Imam in death, but was against standard protocols. There is no explanation from the police in whose custody the Imam was to state who removed the Imam's clothing and for what purpose was it removed. Furthermore, whilst the Imam had received clean clothes from his family and the family received back used clothes from the Imam through the period of his detention. This was not done specifically from the 17th of September 1969. In my view, all this indicates that this was to cover up any form of adverse evidence that the clothes that the Imam used would tell about his state of health. Any possibility of any evidence which may help establish the truth about the condition of the Imam being established was suppressed, if not obliterated. Beggar was called to testify in the reopened inquest. It was noted that he was the last remaining police officer from that period and was just under 25 years and a junior in terms of rank in 1969. In his own words, he was now in an age where he forgot things, but if reminded, they probably came back. His qualities of mind and character had somewhat changed, but not completely. Out of his own accord, he told the court that what he was about to say, what he carried with him for all these years. He broke down here in court and had to be served with a glass of water. Thereafter, he told the court about what he saw, to wit, that the Imam was tortured. He had not only expressed this to the investigating officer, but he had met the Imam's family and even visited them, and also took their grandson, who came from London, to both Caledon and Maitland and showed him the cells and the stairs at both stations. Although he could only explain how to access those in Caledon, he took the grandson to Maitland and showed him the stairs there as well as the cell where the Imam was detained. He also showed the son to record this on a video camera as he showed him what he experienced of the Imam. What is worrying to me is when Beggar attempted to suggest that he only became aware of the extent of the injuries of the Imam when the investigating officer Peterson showed him the pictures in 2020. Beggar was untruthful on this point. He could not have discussed on his own version his burden with his wife and children throughout the years, according to him, because of the absence of a platform to freely open up to speak to a court or the Imam's family through the court, if he only came to know the truth about the Imam's torture in 2020. Beggar found it curious and unusual, with the benefit of hindsight, that the Imam's case was investigated by the security branch members involved in his detention and interrogation, and not by Maitland detectives. It appeared to him that the security branch wanted to control the investigation. The security branch also decided what should and should not go into Beggar's statement, which he made in the 1970 inquest. When Pinar told Beggar that the Imam fell at Maitland police station when he was taking Beggar's statement, Pinar was surely fishing out a possible fabricated version to explain the Imam's death. The response of Beggar, that the stairs in Maitland were only 4, small, and would have caused someone to fall forward and only probably injure their knees, if injured at all, clearly caused Pinar to abandon that explanation as the cause of the Imam's injury. Beggar had no reason to fabricate that kind of discussion between himself and Pinar at the time that he made the statement in December 1969, to wit, that he was shown a diagram and pointed at an injury and told that it was sustained at Maitland where the Imam fell on the stairs in Maitland. Beggar had personally fallen on those stairs in Maitland 3 or 4 times before December 1969, and that is how he knew that when you sleep there, you fell forward and landed on the stairs with your knees. He always stood up and was fine. Beggar was adamant that in the interview where his statement was taken in 1969, the stairs in Caledon, where it was alleged in the 1970 inquest was the scene of the Imam's alleged fall, was never mentioned. It may be so that Beggar did not physically see the Imam's injuries in 1969, if the Imam was at all times clothed when Beggar saw him. If his relationship with the Imam was what he suggested, this is highly unlikely. Beggar saw the Imam including in the week 20 to 27 September. He saw in 1969 that the Imam was not walking in the courtyard during exercise time, especially in the last 2 weeks before the Imam's death. He must have seen that the Imam was not only mobile, but was sedated, bedridden, and in pain in the period 20 to 27 September 1969. Beggar tried to create the impression that the Imam moved on his own and carried his clothes, pillow and food from the whites-only cell back to the cells where he was ordinarily kept on the morning that the Imam died. Beggar's version that the Imam was that morning seemingly healthy and walked without any difficulty, and that at exercise time the Imam just stood in front of the cell door is rejected. Beggar's version that the Imam had no complaints that morning is false. On Beggar's own version, the Imam complained of stomach pain. If it is said that Beggar tried to shift the responsibility for the failure to provide the Imam with medical attention to the Imam himself by suggesting that it was the Imam who did not want to see a doctor in his obvious hour of need, but only needed painkillers and toilet paper. The evidence that during that time of pain, the Imam would have had time to change from sleeping clothes to normal clothes and back to sleeping clothes that same morning showed how low Beggar was prepared to stoop to create the impression of a healthy Imam, when the true facts which were known to him showed otherwise. Dr. Kosso did not do the procedural work of medical personnel arriving at the scene. There was no record of his observations and his findings. There was no record of any special features that he noted, or that there were no special features at all. There is no record of the immediate environment under which he found the Imam's body. There is no record of his determination of when exactly in the day the Imam passed away, against the background of the obvious interference by the police with the body of the Imam, in that they removed his clothes, and their interference with the scene in that they scrubbed and cleaned the cell in which the Imam was detained. The death interval of the Imam provided by the police remains suspect, but that's what we live with. The significance of the circumstances of the finding of the body is important, in that Dr. Shua, Dr. Molefe, and Dr. Naidu agreed that those circumstances cannot be ignored and cannot be divorced from the findings on the body. According to Dr. Molefe, both local and international practice was that it was the pathologist on call and not the district surgeon, as it was the case with the Imam, who would go to the scene and carry out an examination of the scene. This was because of the complexity of the death of a detainee in custody. In the Imam's case, not only was there no pathologist who carried out the examination on the scene, there was also no record of the crime scene report by a medical practitioner. In a death in custody, there ought to be a determination of the death interval, which refers to the estimated time of death. The 1970 inquest was told by the SB that the Imam was found dead at a specific time and day. It is significant that it was Spinner who commissioned Dr. Kosso's affidavit. For all intents and purposes, it seems that Dr. Kosso's role was simply to give medical credibility to a statement by the security branch. According to Dr. Shua, if the Imam had slipped on the stairs and came down on his back toes, and even if he moved slightly to his side as he tried to get erect, that description of the fall would not account for all the bruises found on the Imam. This was because there was no evidence of any injury on the Imam's buttocks. The injury was on the posterior surface of the right leg, and on the anterior surface there were multiple bruises. It is possible that the injuries on the right leg could have been caused by the fall as described, but the person must not only have slid on his buttocks, but also turned to a certain extent, approximately 180 degrees, in order to obtain the injuries on the anterior surface of the right leg, for that portion of the leg to make contact to sustain those injuries. The bruise over the anterior lateral inferior part of the rib cage and the near 3 bruises on the left side of the rib cage cannot be accounted for by the fall on his buttocks. Dr. Shua said if there was a railing and the Imam fell against it, he could have sustained such injuries. The fall would have included falling onto his chest a little, onto the one side, and then in the fall also on the other side. Only then could the fall explain for the injuries. But according to the evidence, the Imam did not fall against the railing or in any way suggested by Dr. Shua to account for the injuries. Dr. Shua indicated that not all injuries could be accounted for by the alleged fall, also as regards their age, as some were fresher than others. And this is also the medical opinion of the other two doctors which testified in the reopened inquest. Dr. Shua indicated that the injury over the lateral part of the left thigh and the injury over the posterior part of the right knee were extensive bruises which could have resulted in such pain that normally the reaction to be expected would be to complain of the pain unless there were other reasons not to complain. Dr. Shua and Stobdman established histologically that the pulmonary emboli was ante-mortem, in other words, before death. Dr. Shua could not exclude the possibility that the pulmonary emboli were a contributory factor. The pulmonary emboli per se was not the sole cause. They were small and they did not obstruct any big vessels, so on their own they could not have caused the death. With the presence of emboli in the vessels, there could be a spasm and this may cause pain. There was a possible interaction between the emboli and the deceased artery. The clotting could have occurred over a period of a week or 10 days. The site of the clotting was in both the left and right calves of the Imam. Dr. Shua said that if the stasis was due to the trauma, then the trauma was indirectly related to the death of the Imam. The source of the pulmonary emboli was the venous thrombosis in the calves. Stasis predisposes to the formation of thrombi. Pulmonary emboli usually occurred about 8 to 10 days after the trauma. Many of the injuries and bruises of the Imam, according to Dr. Shua, were received round about the 17th to the 19th September, according to their age and appearance. The injuries found on the Imam were consistent with trauma, that is, an assault inflicted upon the Imam. According to the three doctors, Dr. Shua, Dr. Molefe, and Dr. Naidu, the bruise on the anterior of the right thigh with two parallel running bruises is found when trauma has been applied when the body comes into contact with a long object with a particular width, like an assault with a stick or something similar. The bruising on the front of the right thigh and over the lower leg were small bruises, and according to the doctors, one can presume that they resulted from trauma inflicted on those specific areas. The three doctors are also agreed that the bruisings on the limbs and the chest cage on the body of Imam were consistent with the result of the assault on the Imam. They also agree that the pulmonary emboli in the small veins of the lungs of the Imam had their origin in the injury on his calves. In my view, it would not be a quantum leap to attribute the subpleural petechial bleeding found spread in the right lung of the Imam also to the assault. As regards the site, the pleura refers to a serous membrane that enfolds the lung, that is, a lining of the lung. Its duty is to protect the lungs and help them to slide back and forth as they expand and contract during breathing. This spread of subpleural petechial bleeding and its relationship to the assault is fortified by the injury discovered after the dissection of the body of the Imam. This injury on the tissue of the anterior lateral inferior part of the right rib cage was not visible with the naked eye. This is also one of the injuries which explain the difficulty of immobility of the Imam and answers why he could not freely walk about or exercise. If regard is set to the age of the injury, it was one of the oldest, which means it was one inflicted earlier than the other two groups as explained in their coloring. Simply put, it was the injury inflicted before the week of 17 September 1969. The seventh rib was broken and there was no fresh bleeding in that area. This was the same area of the bleeding lining of the line, the right side of the Imam's chest. The foremost post-mortem findings of Dr. Shah in relation to the body of the Imam was coronary atherosclerosis, pulmonary emboli, subpleural petechial bleeding, and bruises on limbs and chest pain. Of these four, 3 are directly related to and find their origin in or are consistent with an assault on the Imam. It is only the coronary atherosclerosis that does not directly relate to the assault. It is important to bear in mind that Dr. Shah did not find that the cause of death was coronary thrombosis. In an answer to the prosecutor at the inquest, Dr. Shah was adamant that coronary thrombosis was not the cause of death. There was no fresh clots found in the blood vessel, and there was no heart attack. There was no myocardial infarctions. Nowhere did Dr. Shah, during his post-mortem or after further investigation, including toxicology and histology, say his primary finding was myocardial ischemia. We should remember that this is what the magistrate found. He mentioned myocardial ischemia for the first time in the witness box in his evidence in chief. According to Dr. Molefe, Dr. Shah did not prove myocardial ischemia on histology. This was because there was nowhere where Dr. Shah said that the myocards showed contraction bent necrosis that was in keeping with ischemia. Dr. Shah himself compiled the histology report, and there was no indication of myocardial ischemia insofar as he has performed the post-mortem. Dr. Shah did not determine the cause of death as the post-mortem as due to myocardial ischemia. He recommended further investigations like toxicology and performed some special investigations like histology after the post-mortem report. After the investigations, Dr. Shah concluded that in view of the fact that it was established that the pulmonary emboli was ante-mortem, the presence of pulmonary emboli became a contributing factor, but not per se the sole cause of the death. According to Naidu, in the condition of the heart found on the Imam, there must have been something that accelerated the heart rate so that it exceeded the demand for the Imam to die of ischemia. According to Dr. Naidu, myocardial ischemia did not occur in a resting place, and we know that the Imam had been motionless for at least a week, sedated and lying in a cold cell. It needed some sort of physical exertion or state of great emotional tension, where the heart rate was very high and the demand exceeded the supply through the narrow coronary artery. The Imam had been immobile for at least a week, from 20 to 27 September 1969. Dr. Molefe and Dr. Naidu were clear that under these circumstances, myocardial ischemia was not the cause of death of the Imam. In the light of the fact that the introduction of myocardial ischemia by Dr. Shah himself was not based on any of his clinical findings, its introduction in the evidence in chief in the witness box without any medical basis cannot be supported. Dr. Shah, in fairness to him, in cross-examination, considered that he could not attribute the death of the Imam to myocardial ischemia. So the medical evidence from the first inquest to the last excludes myocardial ischemia as the cause of death. Whilst Dr. Shah collected the blood specimen from the Imam, not all of the results of the special laboratory examination of that blood was disclosed to the magistrate, if those other examinations were ever done at all. The results would have assisted in the type of drugs which was given to the Imam. Considering the totality of the evidence, 3 specimens were taken for specific further investigation, according to Dr. Shah's post-mortem report. It was the blood sample, the liver, kidneys, and stomach, as well as various tissue. I understand the nature of the envisaged investigation, according to Dr. Shua, to have been a toxicology routine investigation to exclude any poisoning and a histological investigation. It is against that background that I understood Van Riet's toxicology report. Van Riet's examination of the stomach, liver and kidney samples showed no adverse substances. In other words, no traces of any poisoning of the Imam. I am unable to read into Van Riet's report that which he did not investigate and report on, to wit, that the toxicological examination of the Imam's blood excluded any traces of drugs like doloxine. Dr. Shua's request was specifically targeted to trace noxious substances, that is, substances that were physically harmful or destructive to living beings. I do not understand Dr. Shua's report to mention any intended investigation of the presence of any drugs or chemical substances that caused a change in the organism's psychology or physiology when consumed. It is against this background that I do not understand Van Riet's report to be saying that there were no such drugs or traces thereof found in the specimen taken from the body of the Imam. When the Imam was moved from Caledon to Maitland in August, as I indicated, he had already sustained some injury, if one were to relate to the symptoms that he expressed to Dr. Vivius, including the lower bend of the state chest cage. From about mid-June, including around 7th and 10th July, the Imam was already complaining about the chest pain. That was before he was moved to Maitland. The evidence showed that the Imam was interrogated daily whilst at Caledon, and that he was also interrogated almost daily whilst detained in Maitland. Other times he was brought from Maitland to Caledon, and sometimes he was visited at the Maitland cells. The Imam was subjected to substantial and intensive interrogation almost daily until shortly before his death. A statement was written from what he said during interrogation from 2 to 7 July. That is the statement spread over days. After being moved to Maitland, the police attempted to deliberately put a blanket of silence about what happened to the Imam. What is, however, clear is that it was after the period of 3 days, in particular 17 to 19 September, of unknown happenings, that the Imam manifested a spike of chest, abdominal pain, headache, immobility, and the prostration to lay in the cell. The Imam spent 123 days in detention, 75 nights in Caledon and 45 in Maitland, except for the 2 nights between 17 and 19 September, where his whereabouts were unknown. It was about 4 months in solitary confinement. It was in conditions of desperation and despair. The overwhelming thought of the lack of prospects of freedom and its consequences to physical health, depression, lack of motivation, lack of appetite, and loss of spirit, that Dr. Naidu's particular concern became the diet and dehydration during that period. It is not certain whether the Imam's hydration was good enough, particularly suffering injuries and the systematic complication, as according to Dr. Naidu, hydration was very important. Nutrition and the state of hydration of the Imam was unknown. The Imam was found in a fetal-like position. This indicated a state of despair and desperation. It is a posture that is not relaxed, a posture that is attempting to get relief. This may relate to the Imam's mental state at the time, but this was also the indication of the mental health consequences. It may also be indicative of the severity of the pain that he suffered. The 12 green and yellow bruises were 7 to 10 days or older, and the red bruises, more on the legs, were more recent, between 2 and 4 days old. The wounds in their respective age categories were inflicted together at around the same time or alternatively over several days. The injuries established when the skin was slapped open during the post-mortem examination were older. The age of the green-yellow bruises were put their age in the region of 17 to 19 September. The red injuries were in the week when the Imam was immobile, between 20 and 27 September 1969. If the Imam fell and landed on his buttocks, it would be understandable for him to have injured the area around his tailbone and the hip bone. In fact, a fracture in that area, the sacroiliac joint, the tailbone or the pelvic bone, would have been most probable. The probability would include a cervical spinal cord injury or even a muscle strain or spasm. The Imam had none of these injuries. He only had localized bleeding outside the blood vessels on the lower back, which was older in age to the injuries attributed to a period around 10 days or contemporaneous with the alleged fall. This injury was not sustained on or after 17 September 1969, but earlier. The Imam had no injuries on his head, neck, and buttocks. His injuries to the thorax were also older than 10 days in age and were not sustained on or after 17 September 1969. The injury pattern on the body of the Imam do not reflect those typically seen in falls downstairs. This was clear not only from the evidence of the medical doctors, but also from the evidence of Mr. Moodley. The Imam's body revealed no injuries to the hands, exposed areas of the back, shoulders, neck, and head. Where a person slips, that is when they lost their footing while descending stairs, it is common for the feet to come forward from under his body and for the person to then fall backwards and land on one or more of the following body parts: his hands, buttocks, back, shoulder, neck, and head. If the Imam fell backwards as alleged, it is difficult to understand how there were several injuries on his anterior legs and chest. There were no injuries to the buttocks, where one would expect to see more bruising if there had been a direct impact of the buttocks on the steps. The absence of injuries on the buttocks, the back aside from the old bruise on the lower back, neck, and head, when considered against the magnitude of the impact velocities that the Imam's body parts would have struck the stairs, the version of the police that the Imam's injuries were sustained during a fall down a staircase is not credible and stands to be rejected. There are significant injuries on the Imam's chest, inner thigh and calf, both chins, and left hamstring, which cannot be connected to the alleged fall. If there had been impact with the upper right outer thigh and the step, Moodley, whose opinion I accept, said you would have expected to see a longitudinal or rectangular shaped bruise as opposed to large general bruising. Speicher said the Imam slipped down one side. There is no evidence that the Imam rolled over, yet there were injuries on both outer sides of the thighs and on the left upper arm. Dr. Viviers, when he examined the Imam in June, excluded heart problems as the source of the pain, as there were no such symptoms. When the Imam was examined by Dr. Gosling later in July, Dr. Gosling found that the Imam's pulse was fast but had no particular irregularity. I accept the evidence of Dr. Stenberg, Dr. Hellman, Dr. Naidu, and Dr. Molefe that the Imam had an uncomplicated coronary artery disease. According to all the doctors who testified at both the 1970 and reopened inquest, there had to be another factor other than coronary artery disease that Dr. Shwa found to cause death. The Imam would definitely not have died at the time that he did and would have survived for years with a coronary artery disease, according to medical evidence. In fact, according to Dr. Naidu and Dr. Molefe, many people who appear healthy and continue to live longer with coronary artery disease, most without even knowing that they have the disease. According to Knight's forensic pathology at page 341, tissue trauma increased the coagulability of blood for several weeks, the peak being 1 to 2 weeks. The injuries to the tissue, especially the legs of the Imam, caused local venous thrombosis, including in the contused muscles. The injuries, especially with their severity collectively, restricted the Imam's movement and confined him to bed. It is the injuries resulting from the assault that caused the blood clots. The injuries would have caused the Imam to have been quite immobile and static. It will not be surprising that he would have been lying down, not wanting to move, and perhaps curled into that fetal position. There was evidence of over 560 square meters of the body with severe bruises. Repeated impact damaged the inner linings of the delicate veins of the calves. The blood became thicker as a result of the trauma, and immobilization increased the stickiness and thickness of the blood. As a result of the deliberate nature was the cause of the injuries of the Imam, an assault of a deliberate nature. The injuries and coronary disease were the only organic conditions that could account for the possible cause of death. These injuries were the primary contributor and primary root to the death of the Imam. The main factor in the cause of the death of the Imam was the wounding. The coronary artery disease was a contributing pre-existing condition. The injuries of the Imam did not cause immediate death. However, they had significant physiological effects. The injuries sustained by the Imam were the underlying primary cause of his death. While detained as a political prisoner in Caledon in 1964 and being interrogated by the SB, Kemp was slapped on her face by a Staker. He also grabbed her by her hair and pounded her head on the floor until she lost consciousness. This assault was so severe that it caused Kemp to be prepared to make a statement about her political activities. When she came to, the SB took a statement from her. It was because of a muddled mind that she was incoherent and unclear. What happened to Kemp was 5 years before the Imam was detained. Kemp did not testify at the 1970 inquest. Her evidence is similar fact evidence. Generally, it is not admitted unless its probative value is so strong that it should be received in the interest of justice, and its admission would not operate unfairly to other parties. It is admitted if it is logically relevant in determining the matter in issue. Its admission, as I said, depends upon its relevance. The primary requirement for the admission of similar fact evidence is its cogency. The evidence must be able to assist the trier of facts to draw reasonable inferences. In other words, having regard to the other available evidence, similar fact evidence must provide reasonable material from which to draw inferences, which will materially assist in deciding the issue before the court. Once it is established, questions of prejudice, justice, and other relevant factors are considered. It is useful if it has sufficient probative value. I found the previous conduct of Speaker and other members of the security branch to be admissible. I have, at the end of this paragraph 166, cited the cases upon which I relied. The evidence of the experiences of other political detainees long after the death of the Imam, like that of Wilcox in 1971, Cronin and Gabru in 1976, and Gunn in 1985 and 1990, could not be led at the 1970 inquest, primarily because their experiences of the security branch were after the inquest. The evidence, however, was relevant to the extent that it revealed the reputation and disposition of the SB during the struggle for the liberation of the black majority of South Africa, in their cases to which I refer to here for that authority. Evidence of bad character is generally inadmissible. However, once a party established a basis for relevance other than merely a lack of credibility, such evidence is admissible. The evidence of these anti-apartheid activists who opposed apartheid in South Africa is being allowed not only to show a tendency of the SIB, of the security branch, to torture political detainees, but also to show a motive for the security branch to torture the Imam. I've given the cases upon which I rely for that paragraph 167. Wilcox was detained some 17 months after the Imam had died in detention. He was one political detainee amongst those who testified, who was in detention almost contemporaneous with the Imam. Wilcox was tortured whilst in detention. Speaker made him to hunch with his back against the wall, his arms folded and held up and not resting on his knees, as if he was sitting on an imaginary chair. Hunching in that position caused him extreme physical discomfort and caused muscular pain in the thighs and legs after a short while. When he could not maintain the sitting position, he slipped to the floor but was made to get up and resume the position. He slipped many times and was made to sit again. Andries placed his foot possibly on his legs and held it. He eventually collapsed to the floor. Andries lifted him by the lapels of his jacket and dropped him from an upright standing position to the floor. This was repeated many times. Lifting him by the lapels, Andries also bashed his back against the wall several times. All the time he was told to talk and refused. Wilcox was made to stand on two slanting bricks placed at an angle on a third brick flat on the floor with his toes on the bricks and his ankles in the air. He was already physically exhausted, and standing on this position aggravated the muscular pains to his legs. When he could not maintain the position and slipped off, he was made to resume. Later, he was made to stand on his toes on two bricks, one on top of the other. This was a great strain on his neck and also his legs. He was made to hold a brick in each hand in his arms held straight above his head. He was made to run on the spot holding the bricks in that position. When his arms sagged, they were pushed up by the security branch. He was also made to walk up and down the room, still holding the bricks in that position. Still with bricks in his hands, he was made to step across a chair several times. He was made to run on the spot with the bricks in his hands, to stand on the slanting bricks, as well as two on his toes several times. Later, he was made to sit on the imaginary chair again. The security member had Wilcox's shirt buttoned and twisted Wilcox's collar with his hand at the back of Wilcox's head, causing him to choke. Wilcox was physically exhausted, and especially his legs were racked with pain. Wilcox was tortured in such a way that he suffered no visible injuries to the naked eye. All the torture was calculated to have him talk, and when he did, it was done to let him talk what was to the satisfaction of the security branch. It was to extract information which the security branch would consider useful. Cronin was detained in Maitland and Sea Point police stations and was every day transported to Culver. His main interrogators included Speaker. Cronin's torture by Speaker was primarily psychological. The security branch adopted a bad cop, good cop roles, with Speaker always being the bad cop. Speaker was the lead interrogator and interrogated Cronin for many hours at a time. Speaker would make threats against Cronin's late wife, family and friends. When Speaker took breaks, the other men would give Cronin advice as to the good cop by suggesting that Cronin cooperate with Speaker in order to avoid what happened to the Imam. He would say things like, "You know what happened to Haron," not directly saying that the SB killed the Imam, but strongly implying it. There was a lot of innuendo in Speaker's demeanor. Sometimes he wore what looked like a butcher's coat, made of white fabric and splotches of dark red on it. Cronin did not know whether it was blood, paint or coloring. Other times he would play with an electrode, clearly signaling that Cronin would be tortured with electric shocks. On a trip to Pretoria, where Cronin was to be further interrogated, Speaker and other 2SB members boasted about how they had dealt with the Imam. The security branch members strongly implied that they had killed the Imam and that Cronin was lucky not to have met the same fate. In Gabru's presence, Speaker and another policeman spoke about slippery staircases and suicides whilst they were walking with him up a flight of stairs. The other policeman, who was bigger than Gabru, pushed Gabru's head over the rail to intimidate and threaten him. It was at that stage that Speaker said, "This is where we killed Imam Haron." The inspection in loco revealed that that was not the staircase, where the security branch alleged that the Imam had slipped, but a different one. The statement by Speaker was intended to instill fear in Gabriel. During most of the interrogation, there would be more than one policeman present. Usually, Speaker sat behind a desk and watched other SB members beat Gabriel with fists and knuckles. He was regularly forced to sit on his knees for hours on end. As a result, his knees were swollen and he walked with great difficulty. On one occasion, he sat on his knees for almost the whole day. The promise of release and returning him back to the cells was emotional and psychological torture. His religion was also used against him, like trying to force a pork sandwich into his mouth when they knew that as a Muslim, pork was forbidden foodstuff. Using his Muslim faith against him, he was told that some detainees would be released in time for Christmas, but not him. The security branch members threatened Gunn that Speaker would be called in an attempt to force her to divulge information. The SB was aware that political detainees had experienced Speaker's cruelty and that he was also associated with the killing of political detainees, including the Imam. Whilst making the threats, the SB would say, "You know what he did to Imam Haron," or "He killed the Imam," or "He took the Imam out," insinuating that Speaker would do the same to her. She was subjected to emotional torture, including having her baby removed from her and placed at a children's home, and when the child was sick, placing her in a hospital cell with no medical care. The security branch in Cape Town subjected the Imam to torture. The psychological torture of the Imam included false accusations, solitary confinement, verbal abuse, threatened violence, given misleading information, threatened with execution of self or family, constant interrogation, threatened with or actual prolonged detention. The physical torture of the Imam included beatings. From the expert opinion of two pathologists who gave evidence in the 1970 inquest, Dr. Shoa and Dr. Helman, and other two pathologists who gave evidence in the reopened inquest, Dr. Molefe and Dr. Naidu, against the background of the totality of the evidence, the Imam's injuries speak out loud for him on the nature and extent of the torture. And in my findings, these tortures include, and I've tried my best to associate particular tortures with the injuries, being repeatedly punched with fists and kicked with booted feet, and this relates primarily to the injuries on the chest cage. These are the injuries, as parties would remember, that were discovered on the dissection of the body. Being repeatedly prodded or pressed either with the knuckles, with the point of a truncheon or similar object while standing against and facing the wall, or lying on the stomach, on his lower back, or whilst lying on his back, or while standing with his back against the wall on his stomach. This also relates to the two older injuries, the one just beneath the navel and the one on the lower back. Being repeatedly given vicious strokes with a truncheon or similar object on the thighs from the front, back and sides. These are the injuries that I found that they were injuries sustained contemporaneous with the period 17 to 19 September. The yellow-greenish injuries. Being repeatedly kicked and thumped upon or stamped on, either whilst standing against the wall or lying on the ground, including on his inner thigh, calf, and on his legs. This also refers to the injuries, the yellowish-green injuries. Being repeatedly kicked or struck or thumped with a truncheon or similar object on his tendon and his shoulders. Here I may mention that the question of being kicked and punched can also not be excluded. And these are also the injuries on the tendon and the shoulders, which are yellowish green. The strokes with a truncheon or similar object on his skull is also possible, and be kicked or punched on his thighs and ankles. Pinar, Gienes, Kotze, Geldernees, Spijker, and Andries were involved in the interrogation of the Imam, and all of them, individually and collectively, subjected him to psychological and physical torture. They individually and collectively caused him the injuries sustained under torture. This also explains why they individually and collectively participated in attempts to cover up the torture and the true cause of death. Kotze and Andries did not testify at the 1917 inquest and did not at any time contradict the version of those who testified. The Imam experienced a steady decline in his health whilst in detention, which correlated with the increasing intensity of interrogations until he was immobile and subsequently died. It started with a pain in his left chest in June, and towards the end of his lifetime in September, he suffered considerable head, chest, and stomach pain, especially from 20 September 1969. The Imam clearly suffered from the effects of a severe force applied to his person. It is the trauma that the Imam suffered between 17 and 19 September that worsened his condition. This worsened condition was known to the SB members and the SAP at Maitland. This worsened condition explained why the security branch and the SAP at Maitland had a special matron, Mrs. Kruger, at the police station itself in Maitland, being responsible, in my view, amongst others, for the administration of doloxine to the Imam in the last week of his lifetime. The 6 members of the security branch, individually or collectively, continued to hit and kick the Imam on his legs, even in the week when he lay helpless, sedated and in pain in the last few days of his lifetime. The search for their truth knew no boundaries and had no conscience. Magistrate Kun had no real desire to establish and search the truth. The version of the police was contradicted by the findings of the forensic pathologist Dr. Schwab, who examined the body of the Imam, and an independent specialist surgeon knowledgeable in pathology, Dr. Hellman, who were clear that all the bruises found on the body of the Imam could not have been caused by the falling down the stairs. Dr. Hellman could not feel the bruises on the Imam's body in front, behind, the sides, including chest, in falling down the stairs. Maybe individual bruises, but not a combination. Dr. Hellman found the alleged complaint of the deceased about stomach pain and not chest pain very odd. You would have expected the deceased to complain of chest pain if he died from chest or heart. Having regard to the Imam's height and the width of the staircase, Dr. Hellman could not see how the Imam could roll down all those stairs unless he banged himself all the way down. The site of the injuries, their circumferential nature, made it difficult to have been sustained in a fall down the stairs. There was no basis for the magistrate to ignore this evidence in favor of the version of the security branch. The uncritical acceptance of the improbable version of the security branch cannot be supported. The police failed to explain on their own version the trauma which could not be explained by the fall, and the magistrate simply said he was unable to determine how that balance of the trauma was caused. This was so even though the Imam suffered those injuries whilst he was in police custody, and no other explanation was provided by the security branch for those injuries. It seems to me that Magistrate Kun saw it as his duty to protect the security branch, and this explained why he did not interrogate their version. The magistrate accepted without question the mere say-so of the security branch. He paid no heed to the cause, nature, and extent of the Imam's injuries. He did not apply his mind to the evidence of the medical experts, and by implication found that even though the Imam suffered injuries whilst in police custody, those injuries were not connected to the actions of the police. He paid no regard whatsoever to the standard of even-handed justice. His decision was not backed by the reasons and logic from the evidence, and he approached the evidence predisposed to the exoneration of the security branch from wrongdoing. The medical experts excluded myocardial ischemia, but he still found it. The magistrate's finding, frankly and candidly reduced to that the Imam fell on his bum and had a heart attack, must count as a joke of the past 53 years. It deserved to be laughed out loud if it did not cause such severe pain and heartache for those who sought the truth and closure. And here follows my findings and order. For these reasons, the following order is made. A. The findings of Magistrate Kun, recorded in the 1970 inquest number 50/70 dated 9 March 1970, as envisaged in section 16(2)(b), as to the cause or likely cause of death, and section 16(2)(d), as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person, are herewith set aside. B. In terms of section 17A, the court records the following finding that differs from a finding made by the magistrate, as well as the respect in which it differs. 1. Section 16(2)(b), finding as to the cause or likely cause of death. The cause of death of Imam Abdullah Haron is attributable to the cumulative effect of injuries under torture, in particular a combination of severe systematic physiological stresses, including crush injury syndrome, precipitated by complications of blunt soft tissue injury, with the possibility of pre-existing coronary artery disease as a contributing factor. 2. Section 2D, finding as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person. The security branch of the South African police are held accountable for the acts and omissions leading directly to the death of Imam Haron, Abdullah Haron. The officers primarily responsible for brutality torturing the Imam to death are: 1. Lieutenant Colonel Karel Johannes Frazen Pinar, who was an officer in charge of the security branch, SAP Cape Town since August 1969. He died on 5 July 1990. Major Derek Kotsachianis, who was in charge of the Imam's investigation and to whom Staker reported. He died on 1 February 2003. Major Kotse, a member of the security branch who interrogated the Imam, his date of death is unknown. Captain Ebenes Johannes Geldenes, who was a superior to Staker. He died on 24 December 2012. Sergeant Johannes Petrus Francois Spijker van Wyk, who was the lead interrogator and investigator. He died on 12 November 1990. Sergeant Andries van Wyk, who participated in the interrogation, his date of death is unknown. The registrar shall forthwith prepare the record of the proceedings and submit it to the Director of Public Prosecutions, Western Cape, without any undue delay. As regards the roles of Johannes Hendrik Hanekomberger, Sergeant Pietras Jacobus Rademeyer, who died on 27 September 2015, Captain Peter Louis Malang, who died on 1st July 1982, and Sergeant Smith, whose date of death is unknown, and the prosecutor J.S. van Graan, the matters are referred to the DPP for a decision. Number 5, the conduct of Dr. Vivius, Dr. Gosling, Dr. Kosu, and Dr. Joa deserves some serious rebuke from the court and is referred to the South African Medical and Dental Council for its attention. I herewith hand down a copy of the judgment. Maybe I should just take this opportunity to thank everyone who made it possible that we hold a successful inquest, starting from the instructing attorneys or the attorneys of record for the family, for the industry that they put in. I think I've already spoken in respect of the investigating officer, the team of the state led by Advocate Machubeni and Advocate Julius, and those who supported you in the work. And in his absence, Advocate Vanier C, as well as Advocate Khan, here present, and the rest of the team. And I should also credit the media for good behavior. All right. Yeah, I normally have not experienced difficulties working with you, and I hope it will continue in this way. Just to indicate that those who have listed their names as recipients, the registrar will email the copy of the judgment to you. Please don't trouble her now that she wraps up the administration work that remains. Thank you. The court adjourned.